You have 14 days to remove all bison from this property. This is a formal notice, not a request. She read it off the page rather than said it, like she'd practiced the tone in her car before she got out. Early 30s, board folder under one arm, the kind of blazer that costs more than my truck payment. She was standing at the cattle guard where my gravel drive meets the county road, and behind her, out past the fence line, 30. One buffalo were grazing the north section the way they'd grazed it every October morning since before I was born. I didn't take the envelope right away. I let her hold it out a second longer than was comfortable for either of us. She had no way of knowing that the desk in my father's study, 40 yards behind me, held a deed with an easement on it. That predated her association by 60 years. She had no way of knowing that 3 weeks before he died, my father had told me there was something about that deed I still didn't understand, something he never got around to explaining. She didn't know any of that. She just knew what her clipboard told her, and her clipboard was wrong. I took the envelope. I said thank you, which surprised her more than anything else I could have said. Then I watched her drive back up the road, and I went inside to call my father's lawyer. If you've ever had someone with a folder and no real authority try to tell you what to do with land your family bled for, tell me in the comments where you're from and what happened. And if these stories mean something to you, stay through this one, because the record my father left behind wasn't just a deed. It was a confession. My name is Marcus Boone. I'm 44. 8 months ago I buried my father, Thomas Boone, on a ridge overlooking 4,000 acres of high grass country in eastern Wyoming. Land his own father had settled in 1951. Land that had run buffalo since 1974, back when my grandfather decided cattle were fighting the ground instead of working with it. I grew up on this land and left it at 22, the way a lot of ranch kids do, chasing something that turned out to be a decade in Denver doing work I didn't love for people I didn't respect. When my father's heart gave out in a hospital in Casper, I came back to bury him and never left again. Somebody had to run the herd. It turned out to be me. The letter Patricia Carlson handed me that morning came from the Ridgeline Meadows Homeowners Association, a subdivision built in 2011 on 260 acres that used to belong to a neighboring family who sold out when the price got good enough. Ridgeline's covenants prohibited large livestock within, and I'm quoting the letterhead, the community boundary and areas of shared community impact. The fine was $600, due in 14 days, with the herd removal demand attached as a separate requirement, same deadline. I read it 3 times at the kitchen table, looking for the part where they explained how a subdivision built 12 years ago on land I never owned had authority over 4,000 acres my grandfather filed on in 1951. That part never came. The letter cited their own rules, like citing your own rules was the same thing as having the right to enforce them on someone else's land. I put it next to my father's reading glasses, which were still sitting on the table where he'd left them, and I went out to check the herd. The second letter came 9 days later, before I'd answered the first. It came from a law office in Cheyenne, and it had teeth in it. References to injunctive relief. References to fines accruing since the original deadline. A deadline that, by their own math, hadn't actually passed yet. I noticed that. I wrote it down. I also noticed that Patricia Carlson had been seen twice on the county road along my eastern fence, according to my neighbor Dale Whitfield, who's farmed the section next to ours for 30 years and doesn't miss much. She wasn't on my land. She was photographing my land from the road, with someone in a polo shirt I didn't recognize standing next to her with a tape measure. She's building something. Dale told me over the phone. You should be building something too. I already was. I started the file that same night, the way my father used to start everything important. A folder, a pencil, a date in the corner. Into it went the letter, the envelope, and behind that, a copy of the deed I pulled from his study. That's when I found the second document. It was folded inside the deed sleeve, behind the property description, in a section I'd never had reason to look at closely. A grazing and mineral rights easement, filed separately from the main deed in 1951, in the name of Eleanor Boone, my great-grandmother, not my great-grandfather. I'd never once heard her name mentioned in connection with the land. My father always talked about the ranch as if his father built it alone. Tucked behind that filing was a letter, handwritten, dated 14 years ago, in my father's hand. It wasn't addressed to me. It was addressed to himself, the way a man writes something down so he won't forget it, or so he won't have to say it out loud to anyone. Eleanor filed the easement in her own name because Dad's debts were about to take the land in 51. She put it where the bank couldn't touch it. She never told him what she'd done until the year before she died. He was too proud to ever admit a woman had saved this ranch, and I let him have that. But if this land is ever threatened again, that filing is the one that matters. Not the deed, the easement. Marcus should know this before I'm gone. I keep telling myself there's time. There wasn't. He died 8 months later, and the story went into the ground with him, everything except the 2 pages he'd left behind for me to find, exactly when I needed them. I sat at that desk for a long time, then I called Dale back, and I asked him for the number of the lawyer who'd handled his own boundary dispute a few years back. Her name was Carol Iverson, and she drove out from Casper the following Tuesday, sat at my kitchen table for an hour with my folder, and said almost nothing until she got to Eleanor's easement. Then she looked up. This predates their entire subdivision, she said. This predates the county road agreement they'll probably try to use next. Has anyone from Ridgeline ever asked you to sign anything, any share, use agreement, anything at all? I told her no. Then, this isn't complicated, she said. It's just going to take paper to prove it, and paper takes time. She was right on both counts. She pulled the recorded plat of the Ridgeline Meadows development the following week, and it confirmed what the easement already told us. The subdivision boundary stopped a full half-mile short of my property line, no shared instrument, no recorded connection. Nothing. 3 weeks after that, right on schedule, Ridgeline tried a new theory, a county road maintenance agreement from 2012, arguing it created a shared standards obligation for adjacent properties. Carol drove to the county recorder's office herself and read the agreement in full. My family's name wasn't in it, neither was the ranch. It governed grading costs on a mile of gravel road between the county and the HOA. Nothing more. Carol filed a request with the county planning office for written confirmation of clear title. 40 days later, it came back, no encumbrance of any kind on the Boone Ranch parcel beyond the 1951 grazing easement, which remained fully valid and superior to any instrument the HOA could produce. That was the document that ended it. Carol filed a petition for declaratory judgment the following week, laying out the deed, Eleanor's easement, the plat boundary, the road agreement, and the county's confirmation, in the order a judge would need to see them to understand what had actually happened here. The hearing was in February, in a courthouse that smelled like every county courthouse smells, old paper, and radiator heat. Patricia Coulson sat across the aisle in the same gray blazer. Judge Renata Alvarez read the file the way Carol had warned me she would, without theater, and asked exactly 3 questions, 2 of which the HOA's attorney couldn't answer without turning pages he clearly hadn't expected to need. 50 minutes later, she ruled from the bench. No jurisdiction, no nexus. All fines vacated, attorney's fees awarded to us. Outside, Dale was leaning on his truck the way he does, and he just nodded when I came down the steps. That was enough. The ranch board sent a letter in April acknowledging the ruling. Patricia Carlson's name doesn't appear in Ridgeline's newsletter anymore. I didn't go looking for either of those facts. They just reached me, the way things do out here eventually. I put Eleanor's letter back where my father kept it, behind the deed, in the second drawer of his desk. I think about her more than I ever thought about her before, a woman who saved 4,000 acres with a filing nobody noticed for 70 years, and never asked to be thanked for it. The herd was in the north pasture the morning I went out to check the fence one last time before the snow came. 31 animals, moving slow and dark against the pale grass, indifferent to every letter, every deadline, every threat that had come and gone since October. My grandfather stood at this fence. My father stood here. Eleanor never did, as far as I know, but she's the reason any of us got to. The land is still here. So is the herd. And now, so is her name. If you've got a story like this one, a boundary someone tried to draw where it didn't belong, a document that turned out to matter more than anyone expected, leave it below. I read all of them, and if you want to be here for the next one, hit subscribe. Next time, it's a water rights filing from 1938, and a neighbor who thought a dry creek meant no one was watching.